and should I start over? Yeah, will do. Thank you. We are now in session for a rulemaking hearing pursuant to sections 24-4-103 and 38-12-1104-2J of the Colorado Revised Statutes. We are going to start with a brief introduction regarding Spanish language interpretation at today's meeting.
Hi, everyone. Can you hear my audio okay?
Yes.
Yes.
Great. So I'm Diego Pons. I'm here today with my colleague, Lina Garcia, and we're here with the CLC. I'll give the instructions in both languages, first in English. Así que voy a dar instrucciones en ambos idiomas, primero en inglés. We're here with the CLC. We're going to be using simultaneous interpretation for the meeting today here on Zoom. As soon as I finish giving the instructions in both languages, the interpretation gets started. At that moment, you'll see a globe icon that'll say interpretation that's going to appear there in the bottom right-hand corner of your computer screen. Please select that globe icon when it appears on your screen, and please select your preferred language. And if you happen to be joining the meeting today on your cell phone or your tablet, you'll instead be looking for the More button or the three dots button to select your preferred language this other way. So if you're not fully bilingual, we strongly encourage you to select your preferred language on your device so you can use the interpretation whenever someone's going to be speaking in the opposite language. And if you're bilingual, then at that moment, you can just feel free to listen to everyone in their original language, and you won't have to worry about hearing our voices as the interpreters. As always, just please pay attention to the speed in which you're speaking. So long as you're speaking at a conversational pace like this, you're going at a great speed for us, but please make sure you don't pick up your reading speed. So thank you so much for that. Buenas tardes a todos y a todas. Yo soy Diego Pons. Estoy aquí hoy con mi colega Lina García, de parte del grupo El CLC. Vamos a proporcionar hoy la interpretación simultánea aquí en Zoom hoy para la reunión en inglés y en español. Cuando termine yo de dar esas instrucciones, vamos a activar interpretación. En ese momento va a aparecer un icono, un globo a la tierra que va a decir interpretación y va a aparecer ahí abajo en la derecha de su pantalla. Por favor, asegúrese de elegir ese icono globo a la tierra y por favor seleccione su idioma preferido. Pero si hoy usted está asistiendo a la reunión en su celular o en su tableta, por favor busque la opción que dice More, que quiere decir más, o posiblemente una opción, un botón de 3 puntos, que le permitirá a usted elegir su idioma preferido de esta otra manera. Así que si usted no es completamente bilingüe, le vamos a aconsejar que elija su idioma preferido para que pueda utilizar la interpretación cuando alguien está hablando en el otro idioma. Y si usted sí es bilingüe, se puede sentir libre de escuchar a todos hoy en su idioma original. Muchas gracias. We can get started now.
Thank you, Diego and Lene. I am Allison George, and I will be presiding over this rulemaking hearing in my capacity as the Director of the Division of Housing. Present are the following individuals from the division: Sam Albrecht, Christina Postlaski, Stephen May, Cassie Vandermeer, and Michelle Grule. Also present are Senior Assistant Attorney General Tori Sampson and Assistant Attorney General Harlan Norby from the Office of the Attorney General. Other division staff will be listening to the hearing via Zoom. We are holding this rulemaking hearing to adopt administrative rules drafted by division staff as a result of multiple public engagement meetings held by telephone and video conference, as well as written communications with members of the public interested in the implementation of House Bills 24-1098 and 24-1294. and previous bills concerning the Mobile Home Park Act and Oversight Program. I will consider the draft rules attached to the rulemaking notice for today's hearing, as well as the written comments submitted in advance of this hearing. Any written and oral comment entered as a part of today's hearing, and any written comments submitted by 11:59 p.m. Mountain Time today. The proposed regulations are filed electronically with the Secretary of State on July 15, 2024, and published in the July 25th issue of the Colorado Register in compliance with statutory requirements. The proposed regulations were filed with the Office of Policy, Research, and Regulatory Reform on July 15, 2024. The Office of Policy, Research, and Regulatory Reform determined on August 3rd that a cost-benefit analysis was not required for this submission since no public requests were received by its deadline. Video recordings of the division's public meetings prior to the notice of proposed rulemaking were posted on the division's website, and the recordings and slides from these meetings were shared with the program's public email list on July 18th, July 3rd, July 18th, June 18th, July 3rd, July 18th, and July 26th. The proposed regulations were posted on the division's website and shared with the program's public email list on July 18th and 26th. Additionally, pursuant to section 24-4-103(3)(b), the Colorado Revised Statutes, each individual requesting notification of proposed rulemaking was emailed a copy of the notice of rulemaking on July 25th. Copies of the proposed rules, as well as statements of basis, specific statutory authority, and purpose are available to the audience upon request. Also available on the division's website are copies of the written testimony provided for consideration in advance of the rulemaking hearing. As a part of the division's early public engagement process, comments in relation to the draft rules were requested by August 7th. Additional comments submitted after this deadline and prior to 11:59 p.m. Mountain Time today, August 14, 2024, will be received and are considered a part of the record. The division received written comments from several individuals and entities prior to today's hearing. Public comments received between July 25th, the date the proposed rules were noticed in the state register, and July 7th are available to the public on the division's website. Comments received before July 25th are available by request. If there are any other written comments that anyone would like submitted and considered part of the record for this rulemaking hearing, please email the comments to mhpop@state.co.us. That is mhpop@state.co.us by 11:59 p.m. Mountain Time today, August 14th, and we will mark them as a part of the record. The purpose of this hearing is to allow interested parties the opportunity to present comments, data, views, testimony, and arguments concerning the rules as proposed. The public is invited to testify at this hearing. All comments will be limited to 3 minutes, and I request that redundancy be kept to a minimum. Each individual offering testimony at this rulemaking hearing must be on the record. Therefore, any person who wishes to speak at this hearing must record his or her name, address, phone number, and the organization represented, if any. We ask that you record this information using the paper or online sign-up sheet before you speak. The online sign-up sheet was shared over email on August 9th, and we are putting a link to the sheet in the chat box for this Zoom meeting. If you have not done so, please sign up now. If you are joining by phone, you can press *9 to raise your hand, and we can unmute your line and add you to the testimony list. Is there anyone joining by phone who would like to testify but has not completed the online form? You can press *9 to raise your hand. I don't see anyone being added.
I don't either.
Okay. Today's virtual hearing is being recorded, and I ask that people introduce themselves prior to testifying. I also ask that you speak loudly and clearly enough to ensure that your testimony is recorded. If you're joining the hearing virtually, you are invited, but not required, to turn on your video while you are speaking. I will consider all the factors outlined in the Administrative Procedure Act during my deliberation of the proposed rules and the written and verbal testimony submitted in response to them. At this time, I would like to call Christina Postolowski, Program Manager for the Mobile Home Park Oversight Program, to provide some clarification and updates on the proposed regulations.
Thank you, Director George. I just wanted to highlight two areas of the proposed rules where the division would like to solicit additional feedback in oral testimony or written testimony today. So the first area of the proposed rules that we wanted to highlight and request additional feedback on relates to mobile home parks that are not opened, where homeowners or residents are not allowed to be during certain months of the year, typically in the winter. These proposed rules are 6.28.2 and 6.16 in the July 25th version of the rules. The proposed rules say that landlords in these properties that are closed for certain months are not required to remove snow or provide running water during the months they are closed to all residents. If there are additional areas where these types of properties would like to provide feedback or believe that clarification is needed in terms of how the Mobile Home Park Act applies to them, we'd like to invite that feedback and testimony today. The second area of the proposed rules that we would like to invite feedback on is Rule 3.11 in the June 25th version of the proposed rules. This relates to certain situations where a landlord may be prohibited from increasing rent in a mobile home park. Specifically in House Bill 24-1294, the state legislature said that landlords are prohibited from increasing rent if in the previous 12 months, the landlord was found by the division in a final agency order or by a court order to have violated section 38-12-212.3 on the landlord's responsibilities to maintain the mobile home park. We are soliciting additional public comments on how long that prohibition on increasing rent should last. We received one public comment that said the prohibition lasts until the landlord has corrected any violations. And we received a contrasting public comment that the prohibition should last for 12 months after the date the final agency order or court order was issued. So we welcome additional feedback on that rule today. Thank you.
Thank you, Christina. I will now call individuals to testify in the order that they are listed on the sign-up sheet. And first on the list is Mary Arlington.
A quick point of question. Do you want me to allow them to be panelists so that they can come on camera?
Yes, please.
Okay. It'll take them a second to reconnect.
Oh, gotcha. Thank you. So on that note, Ryan Siemens is up next after Mary so that you can prepare.
Can you hear me?
Yes.
Thank you. My name is Mary Arlington. I'm the Executive Director of the Colorado Campground and Lodging Owners Association, and I appreciate the time that you've given here today. Our biggest concern across the board is the differentiation between housing and lodging. And the campgrounds, the vast majority of 400 and some campgrounds in the state are focused on lodging vacationers and short stay people who are here for reasons other than residential. They actually have residential homes elsewhere, maybe in the state, maybe in a different country or at least a different state. And so what we're really, we understand your need to find a place to put everybody, but at the same time, there's this vast difference between housing and lodging, and we're begging you repeatedly to not include the RV parks and campgrounds in this ruling. In testimony expressed already in the past, I've shared that some of these mobile homes that are on some of the campsites are actually for extended family, maybe multi-generationals of ownership of these campgrounds. And They're not there because of residency, they're there because of familial or work-related ties to the business of the RV park or campground. And we also know of times where a campground has gone to sell, and only in the due diligence process of trying to figure out what the county knows about the property, it's been determined that there maybe 40 years ago, there was a mobile home on a site, but that mobile home has been gone for decades and has been used for RVs. And so we don't want to be clumped into residential laws when we work so hard to be serving guests, vacationers, and those who are not residents. So all we're asking is that you continually look at everything that you're making everybody jump through and say, is this relevant to the campgrounds? And if need be, create different ruling. What is a definition of a campground?
Thank you, Mary. I don't have any follow-up questions. Christina Harlan? Thank you. Thank you for your testimony. Ryan Siemens, you're up next. Please state your name, address, phone number, and the organization that you represent.
Hi, can everyone hear me now? Sorry about that. I was having a little.
Yes, we can hear you, Ryan.
Okay, hi, everybody. Thank you for the forum. Ryan Siemens. I represent CC5 Vallecito, which owns a campground like Mary was referring to in Bayfield, next to the Vallecito Dam. And we settled a lawsuit. It's a little personal for us because we settled a lawsuit brought by a plaintiff attorney representing 10 of our seasonal guests. And I think I had the same questions that Mary had. Effectively, we understand that the original law was intended to protect working class Coloradans who live in mobile home parks. We understand that, and I think that's a very admirable legislation. Where I think it either purposefully or unintentionally went to include RV park, campgrounds, tourism businesses. None of our residents or none of our guests are Colorado residents. There's no employment to speak of, and it's only open 5 months a year. It's at 8,000 feet, impossible to get to, impossible to provide water and electricity in the off season. So we just think, we're maybe an anomaly here. But I think that the new HB 24-1294, adds, obviously it removes the continuous occupancy standard and also adds tiny homes and things. And my guess is that 50 or 90 Colorado RV park or Colorado campgrounds rather will be included in this legislation. I don't know if that's intentional or not. And so I know this is a rulemaking forum. And so to the extent that the rulemaking body can exclude 100% tourism businesses without any working Coloradans, I think that would be laudable. And we'd appreciate your consideration.
Thank you, Ryan.
Thank you
for your testimony.
Thank you.
Christina Harlan? Okay, thank you. Amy Bove, you are next, and then Benjamin Goldberg is after Amy.
Hello. I am Amy Bove. I own Bove Law, where we represent over 18,000 mobile home lots here in the state of Colorado. And I am specifically talking about Rule 6.15, portable water in times of water outages, as well as 6.16, toilets. What I'm here to talk about today is what operationally works at the ground level. What you can see around me and in the back and in my lobby is what the current rule is proposing for the first day. A family of 3, that's just 3 in my experience, we average anywhere from 5 to 6 people in a mobile home. But we are looking at 60 gallons of water as the rule is written right now. And I looked at that because it first says underneath the rule that we need 2 gallons per person after 12 hours of an outage. I don't have an objection to that. But then we jump to 18. This is when math gets real important about the amount of jugs of water we're gonna have in these mobile homes. So what am I proposing? Well, number one, I was like, where did we get the 20 gallons for hygiene per person? The second Google search is a 15-minute shower takes 20 gallons of water. Well, if we're in the level of this, we are in an emergency. That means the high volume water pipes that can provide a shower for 15 minutes don't work. The idea to legislate and rule make to pretend the pipes still work, because nobody's gonna be pouring these into the water thing, right? But what are they gonna be doing? They're gonna be storing them in their homes. They're going to be delivered. So if we have a 4-day water outage, a catastrophe, an emergency, absolutely. With a 300 spot park, we are looking at 200,000 1 jug gallons of water. Number one, are we gonna be able to get that much water? And if we give everybody 20, when we get to lot 200, is there gonna be any water left? The answer is no. So let's talk practicality here, right? What do people need in this state of emergency? Well, I didn't go to Google, I went to the CDC. I find it to be a little bit more persuasive. And what I am proposing, because the CDC says 1 gallon per person is enough for drinking and hygiene. And then on the 72nd hour, 2 gallons per day. Well, what I'm saying is, let's cut the baby. Let's compromise. If we are at 72 hours without water, once again, I'm not belittling how terrible that is. Let's give 10 gallons per person. So that is 30 gallons of water. Let's remember, we have to put these somewhere in somebody's house or on their lot, right? And then each additional day, they can get 10 gallons. If they need more, they can request. And this is why this is such a great rule, guys. I'm gonna have Ben write it. He's gonna get it to you, Mr. Goldberg, is that when they request for more water, we can pick up the jugs. Because at the end of this emergency, we could have a plastics debris emergency of over 55,000 of these guys. We cannot ignore the practical knowledge.
Thank you, Amy. Yeah, you're at time.
And then the toilets also, guys, the toilets won't allow for parking the amount if we have one toilet for each 4 homes. It is recommended.
I do have a follow-up question.
Thank you.
And I believe Ben is from your office as well, and so he's next.
Yes.
So what you're recommending is 1 gallon upon the immediate occurrence, and then 2 gallons a day after 72 hours. Is that your recommendation?
No, let me clarify and talk slower. I apologize. I am proposing 10 gallons after 72 hours. The statute does say enough for drinking and hygiene after 72 hours. I don't think, practically speaking, people are gonna fill up a bathtub for each member of the household. So 10 gallons, that would be 30 of these a day after 72 hours with an ability to request more water if needed. And then what I would recommend my clients do is pick up the empties at the same time, so we're not left with a plastics catastrophe that's gonna blow not just around our community, but our neighboring communities that we value very much.
Okay, thank you, Amy. I appreciate that.
And we will provide that drafted rule to you before midnight tonight.
Thank you. Christina, Harlan, Lori? Okay.
Just a request for the CDC link when you send over your suggested language.
Absolutely. And then if there is time at the end, I would also like to speak about the number of toilets and how the proposed amount of toilets would greatly impact the flow of traffic and parking, much less the ability to source that amount of toilets in the state of Colorado, which my firm has personal experience with. Thank you. I'll send a proposed rule.
Thank you. Benjamin Goldberg is next, and then Jake Wallace is after Benjamin.
Good afternoon. Thank you for spending the time to hear our feedback today. My name is Benjamin Goldberg. I am a senior associate attorney at Bove Law. Like Amy said, we specialize in this industry, representing manufactured home communities throughout the state, representing 18,000 lots. And I just want to thank the program for willing to work with us. I've been very involved in the feedback here and would like to just provide some more. So today, what I am speaking on are rules 3.7 and 6.13. These rules state that a water disruption is measured in the aggregate, meaning if a water is disrupted for 12 hours in a 96-hour period, on that 12th hour, the requirements that Amy spoke about are triggered. Now, it is my position that this is exceeding the program's delegated authority because it's exceeding the language of the statute. The statute states that specifically CRS 38-12-212.3 subsection 1B Roman numeral 2 states in quotes that water should be provided no later than 12 hours after a service interruption begins. This is clear that that number is counted consecutively on the 12th hour that water is provided. Now let's think about the practical effects of this rule. So for example, the water has gone out in the middle of the night. It's been out for 9 hours. The residents wake up, they see they don't have water, but within an hour, the water is back up. We now have a 2-day gap, 48 hours, where the residents are able to use toilets, use water, shower, cook, do what they need to do. Then after 48 hours, there's a 3-hour disruption. Now, this is still a water disruption. It's still serious, but it's not triggering those requirements on the 12th hour because they've had this entire gap to use the water. So it is my position that the statute is clearly unambiguous, and the case law says clearly unambiguous statutes or regulations will be enforced as intended without interpretation. Therefore, I am asking that rules 3.7 and 6.13 are not implemented because they exceed the granted authority by the legislature. Thank you.
Thank you, Ben. I do not have a follow-up question. Christina? Harlan? Thank you, Ben.
Thank you.
And we have Jake Wallace and Tawny Payton here after Jake.
Good afternoon, and thank you for your time today. I'm Jake Wallace, an associate attorney at Bove Law. We represent roughly 18,000 lots across Colorado. Today, I wanted to raise some concerns with the proposed language changes to Rule 7.2. This rule change creates a narrower definition of utility than previously utilized, limiting a landlord's ability to change the methodology of utility billing to only water, sewer, or stormwater. Colorado Revised Statute Section 40-1-103 defines a public utility as any entity that provides services to the public for domestic, mechanical, or public uses. These utilities provide services other than or in addition to water, sewer, and stormwater services. This rule should not be limited to only some utilities. It should cover all utilities. The plain language of the enabling statute is to apply the term utilities to all services provided to the public, such as water, sewer, trash, electric, gas, and stormwater. Operationally, all utilities are essential to housing residents. By narrowing the scope here, you are impacting a park's ability to offer satisfactory housing to a crucial population within our state. For example, this rule change will hinder a park's ability to provide proper trash pickup services moving forward. Parks must have the ability to adjust all utility billing, provided they provide proper notice, including trash, to ensure proper park maintenance and compliance with all local code. Parks do not profit from their ability to change the methodology of utility billing. Parks only pass the actual cost of utilities on to residents. Everything is getting more expensive these days, so parks need some flexibility to adjust the methodology of utility billing for all utilities. We are requesting that you do not edit Rule 7.2 and that you keep it as currently written. Thank you.
Thank you, Jake. I do not have any questions, sorry. Christina? Okay. Our next person is Tawny Payton. And there are actually two Tawnys. Is it possible that there is another Tawny out there, or Slattery? No. Okay. Then I think we might have a second testimony from another Tawny. Wow. But Tawny Payton, you're first.
Okay.
So you have 3 minutes.
Okay.
Thank you.
Well, thank you. Thank you for hearing my comments today. I submitted written comments just because I knew that I wouldn't be able to cover everything within the 3-minute testimony. So I would like to echo much of what's already been mentioned. I also agree with the consecutive 12-hour outage versus, the just 12 hours collectively. And I would also like to reference maybe considering typical waking hours versus if the outage, many of the hours are during the night hours. And I would like to point out, with all of these law and rule changes, it continues to become more and more expensive to operate communities. We understand that when issues arise, that they need to be addressed. But unfortunately, one of the negative impacts is that I am continually seeing more and more small operators exit our industry. And while we appreciate the large owners who have the resources to comply with all of the regulations, it's unfortunate that these mom and pops who could potentially be multi-generational are now exiting this industry just because of the burdens of regulation. I'm seeing it even as close as one of my friends who they have received a notice that their property is selling. And their rent has not been increased in the last 2 years. And when it was raised, it was only $20. So this is an impact. One example is the porta potty issue or the rule where it's requiring 1 porta potty per 4 households. Just a quick search results in a porta potty costing $275 per porta potty, plus $75 setup and delivery. And there's a chance that you won't even receive that porta potty that same day. It won't be until the next day. And so when you start to run those numbers, if you have a 400 site park, 100 porta potties is going to run, you're talking hundreds of thousands of dollars just to provide portable toilets. So I really encourage you to look at, the CDC requirements, maybe even event planning. I know when I go to outdoor events or whatever, they don't have 1 porta potty per X number of people. As far as, if there's 4 to 6 people per household, we're not looking at 16 to 24 people for each porta potty. So I just really encourage you to reconsider some of those requirements so that they're more realistic and attainable and achievable. I don't know how a property owner collects enough reserves to be prepared for a response like that without increasing rent significantly. So I just really want to encourage you to think about what it's going to take to implement some of, the preparedness for these rules if they're passed as they are. We're looking at emergency response versus long-term response, and I think that that's something to consider as well. Maybe when you're looking at the requirements for facilities and supplies.
Thank you for your time.
Thank you.
So I do have a question because we're talking about emergency rules now, and you were talking about the increase of costs. And so these are in emergency situations. So I'm curious what additional costs you're seeing that are impacting the small parks, really beyond, the emergency situation.
One example is just the complaint program, just the responses to the complaint program and how it's in an owner and operator's probably best interest, not always, but to work through their legal counsel to help them through that process. And also just the short response periods to reply to summons from the state. It adds costs because there isn't flexibility of responding in a longer period of time.
Thank you. That helps with my understanding. I appreciate it. I don't have any other questions, Christina. Okay, thank you. Okay, next on our list is Larry Satellite Man. And after Larry is Jack Regenbogen.
I don't see Larry on our list of attendees. If you are using a different name, can you please raise your hand?
With PID Management. Larry. Not satellite, it's Sliderman. Okay, then we will move to Jack Regenbogen, and after Jack is Michael Pierce. Jack, are you on the line? There you are.
Hi, can you hear me okay?
Yes.
Great, thank you, and good afternoon, everyone. My name is Jack Regenbogen, and I'm the Deputy Executive Director of the Colorado Poverty Law Project. Thank you for developing these proposed rules and for considering our feedback. Today, I would like to elevate 3 comments from our written feedback. First, we would ask that you consider eliminating or reworking proposed Rule 12.1, which as drafted would create a significant barrier to language access accommodations. In our practice, we have had many clients struggle to avail themselves of their rights when they are required to provide specific requests in writing. And that's true even for people who speak English as their primary language. For park residents with limited English proficiency, providing written notice in an unfamiliar language can be nearly impossible. And while it may be beneficial for landlords to keep a written record of language access requests, that should be their prerogative to make and to keep that record. There is simply no statutory basis for this proposed rule, and in fact, it would be contrary to the clear legislative aims in House Bill 1294. In practice, this proposed rule would undercut efforts to ensure clear communication between management and residents, and inevitably would cause preventable conflicts and evictions. Secondly, in proposed Rule 3.14, we ask for clarification that when there's been a determination that a landlord has failed to uphold their core duties under 212.3 of the MHPA, they are prohibited from raising rents for 12 months from the date of that determination. This policy is needed to prevent landlords from neglecting their responsibilities and then avoiding accountability by passing on costs to residents through immediate rent increases. And while House Bill 1294 was under consideration, this was both the expressed and understood aim of this provision, which is distinct in being the only circumstance that's listed in 204 subsection 4 that includes a specified time frame. This is also reflected insofar as the original bill included a prohibition on raising rents for 24 months from that determination, but this was lowered to 12 months through a negotiated amendment. The proposed rule should make clear that this type of legal violation results in a 12-month prohibition on rent increases, or otherwise, park residents will be disincentivized from reporting dangerous conditions. Finally, CPLP appreciates the proposed rules in 6.4b concerning presumptively unenforceable park regulations. However, we would suggest including 3 other items: rules that categorically prevent subleasing or roommates, rules that impose eligibility screening criteria stricter than what's allowed under Colorado's Rental Application Fairness Act, and then rules that require or restrict aesthetic aspects of mobile homes or their structures. In our experience, these types of rules are inherently arbitrary and do not serve any necessary safety purpose as required by the MHPA. And as such, we would urge that these types of park rules be included as either presumptively or per se unenforceable.
Thank you, Jack. You're at time.
Thank you.
I don't have any follow-up questions. Christina?
No.
Arlen? Tori? No. Okay, thank you for your testimony. Next on our list is Michael Pierce. See Michael on the line.
I can see that I'm not muted anymore, but I'm not seeing my picture.
I tried to promote you to panelist a bit ago. Let me try one more time. He's rejoining.
Hi, my name is Michael Pierce. I'm with the Colorado Coalition of Manufactured Homeowners. And I represent both the residents of mobile home parks as well as the perspective of resident-owned communities who are both working for the homeowners and also trying to convey the experiences of management, where we're trying to accommodate the laws that have recently been proposed and to fulfill the requirements. And we're trying to do a balancing act between providing what is reasonably asked by residents in terms of services from the landlord, as well as keeping rents within an affordability level. So much of what I have to say is really for the residents, but again, trying to provide the services, but at a price point that isn't increasing the rents significantly. So I'm finding it peculiar that I'm agreeing at this point with quite a few of the comments that are from management companies with regard to rules and how the new laws are being implemented. And I wanted to flag a few of the rules here. One is as was brought up, the number of toilets per lot. I'd also like to bring up the lighting of the portable toilets, also the service disruption of the water. I think also it's very important for service disruptions to realize the nature of a service disruption and the problem solving that needs to happen while the service disruption is happening. Oftentimes you don't know if you're going to be able to fix it in time until roughly 12 hours after you've discovered that there has been an outage, and you don't know whether you can repair it on time. And it's really between the 8-hour and the 12-hour point of having discovered an outage that you have a sense of how quickly you can actually address the repair. And that's about when you can start to have a good idea as to when to schedule something as significant as a very large delivery of jugs of water, or a water truck if that's what's required. So a number of these issues I'm bringing up seem to be ways of interpreting the statute that aim for the ideal, rather than what I would view as the floor of what would be minimally needed in order to satisfy the statute as written. And I would actually like to recommend that the way the rules are written be oriented towards the floor. What would be a minimal requirement, a minimally decent way of achieving the goals of the statute?
Thank you, Michael. You're at time.
Okay, thank you.
Thank you for your testimony. I don't have a follow-up question. Christina? Do you have? Okay. Helen? Corey? Okay. It appears we do not have any more testimony. There's no one else on the testimony list. Therefore, the comment and testimony portion of this rulemaking hearing is now closed. I will review and consider the written comments, data, views, testimony, and arguments that were submitted to me and received by August 7, 2024, and any others submitted prior to 11:59 p.m. Mountain Time today, August 14th, in conjunction with the oral comments provided here today, before rendering a decision on the adoption of the proposed rules. I have 180 days in which to adopt all or parts of the proposed rules and any amendments to them. After adoption, the rules will be forwarded to the Attorney General's office with a request for an opinion on the constitutionality and legality of the rules. I will instruct division staff to also send a copy to interested members of the public, in addition to posting them on the division website. On or before the 12th day following the adoption of the regulations, the rules and the opinion of the Attorney General will be filed with the Secretary of State for publication in the Code of Colorado Regulations. On or before the 20th day following the adoptions of the rules will be filed with the Office of Legislative Legal Services as required by law. Any adopted rules become effective 20 days after publication of the adopted rules in the Colorado Register. I close the rulemaking hearing at this time. Thank you for your cooperation. It is 1:45 p.m. Thank you.
We'll leave the Zoom open for just a moment to save the chat and the recording.